Chapter 7-A Reciprocal Arrangements for Assistance in Certain Matters and Procedures for Attachment and Forfeiture of Property. This is smallest chapter of Criminal Procedure Code. Why it has been named 7A? Because in chapter 7 reciprocal arrangement was made in 1973 when Criminal Procedure Code was enacted, but later on they have to add reciprocal arrangement with other states, so they have to insert this chapter and name it as chapter number 7A. Chapter 7A was inserted by the amendment of Criminal Procedure Code in the Criminal Procedure Amendment Act 1993. This was done to deal with the reciprocal arrangements with the contacting states, means country, place which is outside India. In chapter 7, reciprocal arrangement was last section as per provisions of section 105. Now in this chapter, which is chapter number 7A, it covers only one section, which is section 105, but it is divided into 12 parts, which is part A to part L. First point is definition, section 105A. Second point, assistant in securing transfer of person as per the provision of section 105B. Third point, assistance in relation to orders of attachment of forfeiture or forfeited of property as per the provision of section 105C. Fourth point, identifying unlawful acquired property as per the provision of section 105D. Next is seizure or attachment of property as per the provision of section 105E. Next point comes, which is the sixth point, management of properties seized or fortified under this chapter as per the provision of section 105F. Next is seventh point, notice of forfeiture of property under the provision of section 105G. Then comes forfeiture of property in certain cases as per the provision of section 105H. Next point is fine in lieu of forfeiture as per the provision of section 105I. Certain transfers to be null and void, it is given under provision of section 105J. Procedure in respect of letters of request. Next and the last, application of this chapter as per the provision of section 105L. A small message before we proceed. I want to say what Socrates has said. I cannot teach anybody anything. I can only make them think. Friends, whenever you come across with someone who says life is hard because I lost my love, who says life is hard because I lost my friend, who says life is hard because I lost my money, do remind them that keep on learning. The beautiful thing about learning is nobody can take it away from you. This words has been said by B.B. King. Let's cover the first point, section 105A, definitions. Clause A of 105A says, Contracting state means any country or place outside India in respect of which arrangement has been made by the central government with the government of such country through a treaty or otherwise. I don't think I need to explain anything. It is just a contract between one country and India, any country with India, and that is to be done by the central government, not by the courts, not by any other person, by the central government department. That is called treaty or some other contract, whichever may be at that time. Next is clause B. Identifying includes establishment of a proof that the property was derived from or used in the commission of an offense. So, an important point is covered in the reciprocal arrangement. Identifying means establishment of a proof. So, if a question comes in examination, does identifying means establishment of proof or not? So, it is. And must remember that it is given in the very beginning of the chapter Reciprocal Arrangement, chapter number 7A. Next is clause C. Proceeds of crime means any property derived or obtained directly or indirectly by a person as a result of criminal activity, including crime involved currency transfers or the value of any such property. So again we read over here that proceed of crime is defined, and it says that property which is either directly or indirectly involved in the criminal activity will be termed as proceeds of crime even if there is an involvement of currency transfer. Next comes clause D, property. Property means property and assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and deeds and instruments evidencing title to or interest in such property or assets derived or used in the commission of an offense, and includes property obtained through proceeds of crime. Now, the property is being defined, and it says it can be any property, whether it is corporeal or incorporeal, and either a property or in an office or corporation. Movable and immovable means which can be moved or cannot be moved, a car or a house. Tangible and intangible, which means breakable or unbreakable, and a deeds and instrument evidencing title to, which means a document which is registered deed or something which shows in whose name the property is. Interest over here means a deed which shows the property may not be in the name of a person but may have a share or may have a share in future. So property has been defined in clause D. Next comes clause E. Tracing means determining the nature, source, disposition, movement, title, or ownership of property. So tracing is connected to the property where the commission of an offense is there, and it is not limited to the property, tracing the property, but in nature, source, and disposition about the title, ownership of that property. Second point of reciprocal arrangement, assistance in securing transfer of property as per the provision of section 105B. Let's cover subsection 1 of section 105B as per the VII-A Act, where a court in India, in relation to a criminal matter, desires that a warrant for arrest of any person to attend or produce a document or other thing is issued by it shall be executed in any place in the contracting state. It shall send such warrant in duplicate in such form to such court, judge, or magistrate through such authority as the central government may by notification specify in this behalf, and the court, judge, or magistrate, as the case may be, shall cause the same to be executed. So, clause 1 of section 105B can be said it is arrest warrant for a person to attend or produce a document or a thing to a person who is abroad, and the procedure will be adopted by the judge magistrate to send such arrest warrant to the central government authority to that authority which the central government may specify by their notification in this regard. Got it? Okay, let's move to the next one. Subsection 2 of Section 105B. Notwithstanding anything contained in this code, if in the course of an investigation or any inquiry into an offense, an application is made by the investigating officer or an officer superior in the rank to the investigating officer that the attendance of a person who is in any place in a contacting state is required in connection with such investigation or inquiry, and the court is satisfied that such attendance is so required, it shall issue a summons or warrant in duplicate against the said person to such court, judge, or magistrate in such form as the central government may, by notification, specify in this behalf to cause the same to be served or executed. Clause 2 of Section 105B speaks about summons or warrant to be issued by the court to a person who is abroad, that is outside India, if in the course of an investigation by an IO is investigating officer or an officer of the IO thinks that for their investigation the attendance of a person is required, and they make an application to the court that the person has to attend for their investigation. Then the process is adopted as per clause 1 of section 105B. Next comes subsection 3 of section 105B, where a court in India in relation to a criminal matter has received a warrant for arrest of any person requiring him to attend and produce a document or other thing in that court or before any other investigating agency issued by a court, judge, or magistrate in a contracting state, the same shall be executed as if it is the warrant received by it from another court in India for execution within its local limits. Now, third point of section 105B speaks about a warrant for arrest in India if it is required by an investigating agency or a court which is not in India. It will be executed by the Indian courts if that country which has issued the warrant of arrest for production of a document or a thing or other investigating agencies must be a contracting state with India. Next comes the fourth point of section 105B, where a person transferred to a contracting state pursuant to subsection 3 is a prisoner in India. The court in India or the central government may impose such conditions as that court or government deems fit. Now, in subsection 3 of section 105B, we read that a foreign country required by the court or the investigating agency for some commission of a crime is to be arrested and sent to that foreign court. But what if that person is already in prison of India? Then subsection 4 of section 105B comes into force. It says that it may be sent but impose such conditions as the court or government may deem fit. Next comes subsection 5 of section 105B, where the person transferred to India pursuant to subsection 1 or subsection 2 is a prisoner in a contracting state. The court in India shall ensure that the conditions subject to which the prisoner is transferred to India are complied with, and such prisoners shall be kept in such custody subject to such condition as the central government may direct in writing. In subsection 4 of section 105B, we read that if a person required by a foreign court is already in prison in India, India can send them to the foreign court but with some conditions. The same way it is now vice versa. If India require a person which is abroad under subsection 1 or subsection 2 of section 105B and that person is already in prison in that foreign country, that country will also be imposing some conditions, and central government will ensure that all such conditions are taken care of. With this, we covered the topic assistance in securing transfer of a person as per the provision of section 105B. Third point of reciprocal arrangement, assistance in relation to orders of attachment or forfeiture of property as per the provision of section 105C. Subsection 1 of section 105C says, where a court in India has reasonable ground to believe that any property obtained by any person is derived or obtained directly or indirectly by such person from the commission of an offence, it may make an order of attachment or forfeiture of such property as it may deem fit under the provision of section 105D to 105J, both inclusive. Subsection 1 of section 105C says Indian courts has the power to attach or forfeit a property of a person outside India. How can they do so? Well, let's come to the next point for that thing. Subsection 2 of section 105C says where the court has made an order for attachment or forfeiture of any property under subsection 1 of section 105 and such property is suspected to be in a contracting state, the court may issue a letter of request to a court or an authority in the contracting state for execution of such order. Now you got the point how the property of a person which is situate outside India can be attached or forfeiture of that property can be done by writing a letter to that contracting state. Now the important thing never to be forgotten is that that country should be a contracting state with India. Otherwise, Indian court will not be having any authority for asking the other country for the execution of such orders. Now let's check the third point of section 105C, where a letter of request is received by the central government from a court or an authority in a contracting state requesting attachment or forfeiture of the property in India, derived or obtained directly or indirectly by a person from the commission of an offence committed in that contracting state, the central government may forward such letter of request to the court as it thinks fit for execution in accordance with the provisions of section 105D to 105J, both inclusive, or as the case may be, any other law for the time being in force. In subsection 1 of section 105C, we read about attachment and forfeiture of a property of a person which is abroad by the orders of the Indian courts to be implemented by the foreign courts. Subsection 2 of 105C was speaking about writing a letter to that foreign country. Now, subsection 3 of section 105C speaks about foreign courts asking Indian government, Indian courts to implement their orders of attachment and forfeiture of a property of a person which the foreign court thinks it has been obtained by that person by committing an offense in their country. With this, the topic assistant in relation to orders of attachment or forfeiture of property as per the provision of section 105C has been covered. Fourth point of reciprocal arrangement, identifying unlawful acquired property as per the provision of section 105D. Subsection 1 of section 105D says, the court shall under subsection 1 or on receipt of a letter of request under subsection 3 of section 105C direct any police officer not below the rank of sub-inspector of police to take all steps necessary for tracking and identifying such property. Subsection 1 of section 105D speaks about those properties which under subsection 105C, subsection 1 and subsection 3, attached or forfeiture of that property has to be done. This duty to identify such properties which the court has ordered has to be done by a police officer not below the rank of a sub-inspector. Next is subsection 2 of section 105D. The steps referred to in subsection 1 may include any inquiry, investigation, or survey in respect of any person, place, property, assets, documents, books of accounts in any bank or public financial institutions or any other relevant matters. Basically, subsection 2 of section 105D is clarifying things which are included in the word property for the police officer to be searched, track, or identify the IO, the investigating officer, for the purposes of any inquiry, investigation, or even survey in respect of that person, place, property, assets, document, books, in accounts of any bank and financial institute as well. You might have learned it by heart by now. Anyway, let's come to the third point. Subsection 3 of section 105D. Any inquiry, investigation, or survey referred to in subsection 2 shall be carried out by an officer mentioned in subsection 1 in accordance with such directions issued by the said court in this behalf. Which means that an inquiry, investigation, or survey by a police officer can be done only on the directions of the court. With this, identifying unlawful acquired property topic is covered. Fifth point of reciprocal arrangement is seizure or attachment of property as per the provision of section 105E. Subsection 1 of section 105E says, where any officer conducting an inquiry investigation under the section 105D has a reason to believe that any property in relation to which such inquiry or investigation is being conducted is likely to be concealed, transferred, or dealt with in any manner which will result in disposal of such property, he may make an order for seizing such property. Where it is not practicable to seize such property, he may make an order of attachment directing that such property shall not be transferred or otherwise dealt with except with the prior permission of the officer making such order, and a copy of such order shall be served on the person concerned. Phew, it seems such a big thing, but there is nothing in this section. Subsection 1 of section 105E is speaking about when an IO, investigating officer, is conducting an inquiry or investigation as per the provision of section 105D, believes that such property will be sold by the person. Well, before that thing is happened, he may pass an order that such property should not be transferred without his prior permission or the prior permission of the officer which made such order, and the copy of such orders will be served to the concerned person. Next is subsection 2 of section 105E. Any order made under subsection 1 shall have no effect unless the said order is confirmed by an order of the said court within a period of 30 days of its being made. In subsection 1 of section 105E, we read that an officer can order that a property will not be sold without his prior permission, which is under his inquiry or investigation or a survey. Such orders by the court will not be effective unless it has been confirmed by the orders of the court within a period of 30 days. Got it? Okay, let's move to the sixth point of reciprocal arrangement is management of properties seized or fortified under this chapter as per the provision of section 105F. Subsection 1 of 105F says the court may appoint a district magistrate of the area where the property is situate or any other officer that may be nominated by the district magistrate to perform the functions of an administrator of such property, which means that where a property is attached or forfeited under this chapter, we need some person to take control, take charge of that property. That will be either a district magistrate or a person nominated by the district magistrate, which is given as per subsection 1 of section 105F. Now, subsection 2 of 105F says the administrator appointed under subsection 1 shall receive and manage the property in relation to which the order has been made under subsection 1 of the section 105E or under section 105H in such manner and subject to such condition as may be specified by the central government. In subsection 1 of section 105F, we read that district magistrate or an officer nominated by district magistrate will be taking care of the property as an administrator. Now subsection 2 of 105F says that administrator will function or manage that property in such manner and subject to such conditions as may be specified by the central government, not by the court. So the functioning of an administrator will be dealt by central government. Let's come to the third point. Subsection 3 of section 105F. The administrator shall also take such measures as the central government may direct to dispose of the property which is forfeited to the central government. Well, subsection 3 of 105F just informing us that the administrator which is nominated by the district magistrate to take care of the property can dispose the property also, but such measures will be taken on the directions of the central government. That ends the topic management of properties seized or forfeited under this chapter. Seventh point of reciprocal arrangements, notice of forfeiture of property as per the provision of section 105G. Subsection 1 of section 105G says, if as a result of the inquiry, investigation or survey under section 105D, the court has reason to believe that all or any of such properties are proceeds of crime, it may serve a notice upon such person, thereafter referred to the person affected, calling upon him within a period of 30 days specified in the notice to indicate the source of income, earnings or assets out of which or by means of which he has acquired such property, the evidence on which he relies and other relevant information particulars, and to show cause why all or any of such properties, as the case may be, should not be declared to be proceeds of crime and forfeited to the central government. Subsection 1 of section 105G speaks about a show cause notice to the person that the property acquired by him is not from the proceeds of crime, the property which is under the inquiry, investigation or survey by the court, and such property should not be forfeited to the central government. Next is subsection 2 of section 105G, where a notice under subsection 1 to any person specifies any property as being held on behalf of such person by any other person, a copy of the notice shall also be served upon such other person. Subsection 2 of section 105G speaks about the notice of forfeiture of property which is given under subsection 1 of section 105G shall be given not only to the person to which the property belongs, but a copy to a person who is holding that property as well on behalf of the owner of that property. Eighth point of reciprocal arrangement is forfeiture of property in certain cases as per the provision of section 105H. Subsection 1 of section 105H says the court may, after considering the explanation, if any, to the show cause notice issued under subsection 105G and the material available before it, and after giving to the person affected, and in case where the person affected holds any property specified in the notice through any other person, to such other person also, a reasonable opportunity of being heard by order record a finding whether all or any of such properties in question are proceeds of crime. Subsection 1 of section 105H speaks about a show cause notice which was served under section 105G. After that notice to the person who is either the owner of the property or person who is holding the property on behalf of the owner will be given a reasonable opportunity by the court, and the court will record the findings of such property in question, whether it or any part of the property is from the proceeds of the crime or not. There is a condition to this, provided that, means subject to condition, if the person affected, and in case where the person affected holds any property specified in the notice through any other person, such other person also does not appear before the court or represent his case before it within the period of 30 days specified in the show cause notice, the court may proceed to record findings under this subsection ex parte on the basis of evidence available before it. Well, it is explaining us that within the period of 30 days of show cause notice of forfeiture of the property to the owner or to the other person holding on the behalf of the owner does not appear before the court, ex parte procedures will be started. Let's move to the next point, subsection 2 of section 105H, where the court is satisfied that some of the properties referred to in the show cause notice are proceeds of crime, but it is not possible to identify specifically such properties, then it shall be lawful for the court to specify the properties which, to the best of its judgment, are proceeds of crime and record of findings accordingly under subsection 1. Subsection 2 of section 105H is speaking about a situation where there are number of properties, but some of them are from the proceeds of crime but cannot be specifically identified which one. Then in such case the court can take a decision accordingly as per the records which property to be termed as proceeds of crime on finding on a record. And next is subsection 3 of section 105H, where the court records a finding under this section to the effect that any property is proceeds of crime, such property shall stand forfeited to the central government free from all encumbrances. Subsection 3 of section 105H says, when the court declares that a property is from proceeds of crime, that property will stand forfeited to the central government, and it will be free from all encumbrances, means that there is going to be no liability and the central government will be free to even sell it to some other persons. Got it? Okay. Let's move to the next point, subsection 4 of section 105H, where any shares in a company stand forfeited to the central government under this section, then the company shall, notwithstanding anything contained in the Companies Act 1956 or the Articles of Association of the company, forthwith register the central government as the transferee of such shares. Subsection 4 of section 105H says, if the forfeited property is in the form of shares of a company, then the central government will be in charge of such shares as a transferee of such shares. With this, we wrap up the topic forfeiture of property in certain cases. Ninth point of reciprocal arrangements, fine in lieu of forfeiture as per the provision of section 105I. Subsection 1 of section 105I says where the court makes a declaration that any property is sent for forfeiture to the central government under the section 105H, and it is a case where the source of only a part of such property has been proved to the satisfaction of the court, it shall make an order giving an option to the person affected to pay in lieu of forfeiture or fine equal to the market value of such part. Subsection 1 of section 105I says that a person can pay fine in lieu of forfeiture property if the court declares that only part of the property has been proved to be the proceed of a crime. And subsection 2 of section 105I says before making an order imposing a fine under subsection 1, the person affected shall be given a reasonable opportunity of being heard. Okay, it's self-explanatory. I need not to explain it. Let's cover the subsection 3 of section 105I, where the person affected pays the fine due under subsection 1 within such time as may be allowed in that behalf. The court may by order revoke the declaration of forfeiture under subsection 105H, and thereupon such property shall stand released. Subsection 3 of 105I is simply explaining us when the person has given or paid the fine in lieu of the forfeited property to the central government, that property will be released. He can enjoy his property as before. That's it. Okay, let's move on to the next one. 10th point of reciprocal arrangement, certain transfers to be null and void as per the provision of section 105J. Section 105J says when after making of an order under subsection 1 of section 105E or the issue of a notice under section 105G, any property referred to in the said orders or notice is transferred by any mode whatsoever, such transfers shall, for the purposes of the proceedings under this chapter, be ignored, and if such property is subsequently forfeited to the central government under section 105H, then the transfer of such property shall be deemed to be null and void. Section 105J is informing us that when a property is seized or attached, or a notice of forfeiture has been given, even after that, the concerned person, the owner or the holder of the property, transfers the property either by sale or by other mode, that transfer of property in title shall be considered to be null and void. This is the reason why buyers always cross-check whether the property that they are going to buy is free from all kind of legal hassles or not. 11th point of reciprocal arrangement, procedure in respect of letters of request as per the provision of section 105K. Section 105K says that every letter of request, summon or warrant received by central government from and every letter of request, summon or warrant to be transmitted to a contracting state under this chapter shall be transmitted to a contracting state, or as the case may be, sent to the concerned court in India in such form and in such manner as the central government may by notification specify in this behalf. Section 105-K is informing us regarding the procedure to be adopted, how the letter of request for serving a summon or a warrant to be done by contracting state. This procedure is specified by the central government from time to time. So it's not a fixed procedure. So that is going to be adopted by the manner the central government may going to specify by a notification. 12th point of reciprocal arrangement. This is the last point of the chapter, and it also says the application of this chapter as per the provision of section 105L. The central government may by notification in the official gazette direct that the application of this chapter in relation to a contracting state with which reciprocal arrangement has been made shall be subject to such conditions, exceptions, or qualifications as are specified in the said notification. This means that the service of summon or a warrant to a foreign state, which is a contracting state, will be done as per the central government notification. That's it, nothing else.